Basically, this is a fairly straightforward case. It's the kind of case we get on a regular basis, which is blogger was using material, copyright owner was asserting their copyright through DMCA takedown notice, and they, in our view, overreached in trying to assert that copyright. But the nature of the DMCA, the Digital Millennium Copyright Act, is such that it's really better to try to get things resolved by just talking to the other side, because going to court is a cumbersome process for the blogger, and our goal is to try to avoid that. So in this particular case, the blogger called us and asked for help. We did two things, which is fairly standard. One is we lined up legal support. So we got a lawyer in the Southern District of New York to help out on the case. We got support from the EFF and from Harvard's Citizen Media Law Project. And then we reached out to the other side to see if we could sit down and talk and get the matter resolved face to face. They agreed to talk, but then we get into a different issue, which is that news accounts of that conversation with AP got very much mischaracterized and turned the story into something that it was not. Well, I think that probably the one that drove the story the most was this idea that the AP had sort of swooped in from left field and identified a relatively small blogger with very minor allegations of copyright infringement, which were questionable. The fact is that AP had been communicating with the blogger in question for about 2 months. There had been dozens of instances where both sides agreed that there had been copyright violations, because the contributors to the site, the Drudge Retort, had been putting up verbatim headlines and whole text of AP articles. That got the blogger on their radar, and as lawyers are wont to do, once they were focused on him, they got out the microscope and started going, very carefully through the rest of the site, looking for anything else that they could allege as copyright. And by the time this became a story, they had gotten into some very picayune examples of copyright infringement that were very questionable, and we were more than willing to push back on. Well, I think because there's so much confusion as to what was actually going on in this case, I think bloggers may have drawn many of the wrong lessons from this case. Probably the most ill-informed lesson that they seem to have taken was blogger outrage works as a way to respond to legal threats. The fact of the matter is the blogger outrage in this case hindered, didn't help getting to resolution. And the opponents of that view have really little knowledge, and probably none, of the actual amount of threats that are out there against bloggers. And so while this case got a huge amount of attention, during that same time period of the past couple of weeks, I've had a dozen other requests for help from bloggers in different legal matters. I can assure you those cases are not going to get covered in the New York Times or the AP or anywhere else. The big bloggers who are writing about this case are not going to pay any attention to them. And so really the question becomes, what happens to those people who can't rely on getting a bright spotlight shown on their case? And that's where we come in, which is a more mundane approach to actually resolving legal disputes with lawyers and with trying to sit down and negotiate settlements.
Well, I think Bob's probably right that this is a fairly typical sort of cat and mouse game. The copyright owner wants to protect their copyright. The one who is borrowing or referring to somebody else's copyrighted work wants to protect the right to do that. And I think there will always be fights between the two of them, and this one got resolved as best they could. I think it's probably just as well that it got resolved without setting down any ironclad rules that would create sort of a private law of fair use between the AP and bloggers. I think we'd all just as soon avoid that, and in many ways the ambiguity that there is in the fair use doctrine probably helps the bloggers in the long run. There are things I think bloggers need to be aware of. You ought to be linking back to the site that you're talking about. You ought not to be copying and pasting the entire AP article or article by some other copyright holder and putting that entire thing on your site. You're probably at greater risk if you're selling ads that work off the content of that borrowed material. You are going to be better off under the fair use test if you are actually commenting about the material that you're quoting rather than simply replicating it. So that you're not simply substituting for the original, but you're adding to it, transforming it, giving it greater meaning. I actually don't, Dan. I think that most of the news organizations see the blogging that comes and refers back to their sites as something that really will drive people back to their sites, get more page clicks for them and more page clicks that they can show their advertisers. In some ways, the AP case is anomalous because of the nature of the AP's exclusive relationships with many of its clients.